Vienna Convention on the Law of Treaties. Done at Vienna on May 23, 1969. Part 2. Conclusion and entry into force of treaties. Section 1. Conclusion of treaties. Article 6. Capacity of states to conclude treaties. Every state possesses capacity to conclude treaties. Article 7. Full powers. 1. A person is considered as representing a state for the purpose of adopting or authenticating the text of a treaty or for the purpose of expressing the consent of the state to be bound by a treaty if a. He produces appropriate full powers, or b. It appears from the practice of the states concerned or from other circumstances that their intention was to consider that person as representing the state for such purposes and to dispense with full powers. 2. In virtue of their functions and without having to produce full powers, the following are considered as representing their state. A. Heads of state, heads of government and ministers for foreign affairs, for the purpose of performing all acts relating to the conclusion of a treaty. B. Heads of diplomatic missions, for the purpose of adopting the text of a treaty between the accrediting state and the state to which they are accredited. C. Representatives accredited by states to an international conference or to an international organization or one of its organs, for the purpose of adopting the text of a treaty in that conference, organization, or organ. Article 8. Subsequent confirmation of an act performed without authorization. An act relating to the conclusion of a treaty performed by a person who cannot be considered under Article 7 as authorized to represent a state for that purpose is without legal effect unless afterwards confirmed by that state. Article 9. Adoption of the text. 1. The adoption of the text of a treaty takes place by the consent of all the states participating in its drawing up except as provided in paragraph 2. 2. The adoption of the text of a treaty at an international conference takes place by the vote of 2/3 of the states present and voting, unless by the same majority they shall decide to apply a different rule. Article 10. Authentication of the text. The text of a treaty is established as authentic and definitive. A. By such procedure as may be provided for in the text or agreed upon by the states participating in its drawing up, or b. Failing such procedure, by the signature ad referendum or initialing by the representatives of those states of the text of the treaty or of the final act of a conference incorporating the text. Article 11. Means of expressing consent to be bound by a treaty. The consent of a state to be bound by a treaty may be expressed by signature, exchange of instruments constituting a treaty, ratification, acceptance, approval, or accession, or by any other means if so agreed. Article 12. Consent to be bound by a treaty expressed by signature. 1. The consent of a state to be bound by a treaty is expressed by the signature of its representative when a. The treaty provides that signature shall have that effect. b. It is otherwise established that the negotiating states were agreed that signature should have that effect, or c. The intention of the state to give that effect to the signature appears from the full powers of its representative or was expressed during the negotiation. 2. For the purposes of paragraph 1. A. The initialing of a text constitutes a signature of the treaty when it is established that the negotiating states so agreed. B. The signature ad referendum of a treaty by a representative, if confirmed by his state, constitutes a full signature of the treaty. Article 13. Consent to be bound by a treaty expressed by an exchange of instruments constituting a treaty. The consent of states to be bound by a treaty constituted by instruments exchanged between them is expressed by that exchange when a. The instruments provide that their exchange shall have that effect, or b. It is otherwise established that those states were agreed that the exchange of instruments should have that effect. Article 14. Consent to be bound by a treaty expressed by ratification, acceptance, or approval. 1. The consent of a state to be bound by a treaty is expressed by ratification when a. The treaty provides for such consent to be expressed by means of ratification. b. It is otherwise established that the negotiating states were agreed that ratification should be required. c. The representative of the state has signed the treaty subject to ratification, or d. the intention of the state to sign the treaty subject to ratification appears from the full powers of its representative or was expressed during the negotiation. 2. The consent of a state to be bound by a treaty is expressed by acceptance or approval under conditions similar to those which apply to ratification. Article 15. Consent to be bound by a treaty expressed by accession. The consent of a state to be bound by a treaty is expressed by accession when a. The treaty provides that such consent may be expressed by that state by means of accession. b. It is otherwise established that the negotiating states were agreed that such consent may be expressed by that state by means of accession, or c. All the parties have subsequently agreed that such consent may be expressed by that state by means of accession. Article 16. Exchange or deposit of instruments of ratification, acceptance, approval, or accession. Unless the treaty otherwise provides, instruments of ratification, acceptance, approval, or accession establish the consent of a state to be bound by a treaty upon a. Their exchange between the contracting states, b. Their deposit with the depositary, or c. Their notification to the contracting states or to the depositary, if so agreed. Article 17. Consent to be bound by part of a treaty and choice of differing provisions. 1. Without prejudice to Articles 19 to 23, the consent of a state to be bound by part of a treaty is effective only if the treaty so permits or the other contracting states so agree. 2. The consent of a state to be bound by a treaty which permits a choice between differing provisions is effective only if it is made clear to which of the provisions the consent relates. Article 18. Obligation not to defeat the object and purpose of a treaty prior to its entry into force. A state is obliged to refrain from acts which would defeat the object and purpose of a treaty when a. It has signed the treaty or has exchanged instruments constituting the treaty subject to ratification, acceptance, or approval, until it shall have made its intention clear not to become a party to the treaty, or b. It has expressed its consent to be bound by the treaty, pending the entry into force of the treaty and provided that such entry into force is not unduly delayed. Section 2. Reservations. Article 19. Formulation of reservations. A state may, when signing, ratifying, accepting, approving or acceding to a treaty, formulate a reservation unless a. The reservation is prohibited by the treaty. b. The treaty provides that only specified reservations, which do not include the reservation in question, may be made, or c. In cases not failing under subparagraphs a. and b. The reservation is incompatible with the object and purpose of the treaty. Article 20. Acceptance of an objection to reservations. 1. A reservation expressly authorized by a treaty does not require any subsequent acceptance by the other contracting states unless the treaty so provides. 2. When it appears from the limited number of the negotiating states and the object and purpose of a treaty that the application of the treaty in its entirety between all the parties is an essential condition of the consent of each one to be bound by the treaty, a reservation requires acceptance by all the parties. 3. When a treaty is a constituent instrument of an international organization and unless it otherwise provides, a reservation requires the acceptance of the competent organ of that organization. 4. In cases not falling under the preceding paragraphs and unless the treaty otherwise provides a. Acceptance by another contracting state of a reservation constitutes the reserving state a party to the treaty in relation to that other state if or when the treaty is in force for those states. b. An objection by another contracting state to a reservation does not preclude the entry into force of the treaty as between the objecting and reserving states unless a contrary intention is definitely expressed by the objecting state. c. An act expressing a state's consent to be bound by the treaty and containing a reservation is effective as soon as at least one other contracting state has accepted the reservation. 5. For the purposes of paragraphs 2 and 4 and unless the treaty otherwise provides, a reservation is considered to have been accepted by a state if it shall have raised no objection to the reservation by the end of a period of 12 months after it was notified of the reservation or by the date on which it expressed its consent to be bound by the treaty, whichever is later. Article 21. Legal effects of reservations and of objections to reservations. 1. A reservation established with regard to another party in accordance with Articles 19, 20, and 23. A. Modifies for the reserving state in its relations with that other party the provisions of the treaty to which the reservation relates to the extent of the reservation, and b. Modifies those provisions to the same extent for that other party in its relations with the reserving state. 2. The reservation does not modify the provisions of the treaty for the other parties to the treaty inter se. 3. When a state objecting to a reservation has not opposed the entry into force of the treaty between itself and the reserving state, the provisions to which the reservation relates do not apply as between the two states to the extent of the reservation. Article 22. Withdrawal of reservations and of objections to reservations. 1. Unless the treaty otherwise provides, a reservation may be withdrawn at any time and the consent of a state which has accepted the reservation is not required for its withdrawal. 2. Unless the treaty otherwise provides, an objection to a reservation may be withdrawn at any time. 3. Unless the treaty otherwise provides, or it is otherwise agreed. A. The withdrawal of a reservation becomes operative in relation to another contracting state only when notice of it has been received by that state. B. The withdrawal of an objection to a reservation becomes operative only when notice of it has been received by the state which formulated the reservation. Article 23. Procedure regarding reservations. 1. A reservation, an express acceptance of a reservation and an objection to a reservation must be formulated in writing and communicated to the contracting states and other states entitled to become parties to the treaty. 2. If formulated when signing the treaty subject to ratification, acceptance, or approval, a reservation must be formally confirmed by the reserving state when expressing its consent to be bound by the treaty. In such a case the reservation shall be considered as having been made on the date of its confirmation. 3. An express acceptance of, or an objection to, a reservation made previously to confirmation of the reservation does not itself require confirmation. 4. The withdrawal of a reservation or of an objection to a reservation must be formulated in writing. Section 3. Entry into force and provisional, application of treaties. Article 24. Entry into force. 1. A treaty enters into force in such manner and upon such date as it may provide or as the negotiating states may agree. 2. Failing any such provision or agreement, a treaty enters into force as soon as consent to be bound by the treaty has been established for all the negotiating states. 3. When the consent of a state to be bound by a treaty is established on a date after the treaty has come into force, the treaty enters into force for that state on that date, unless the treaty otherwise provides. 4. The provisions of a treaty regulating the authentication of its text, the establishment of the consent of states to be bound by the treaty, the manner or date of its entry into force, reservations, the functions of the depositary and other matters arising necessarily before the entry into force of the treaty apply from the time of the adoption of its text. Article 25. Provisional application. 1. A treaty or a part of a treaty is applied provisionally pending its entry into force if a. The treaty itself so provides, or b. The negotiating states have in some other manner so agreed. 2. Unless the treaty otherwise provides or the negotiating states have otherwise agreed, the provisional application of a treaty or a part of a treaty with respect to a state shall be terminated if that state notifies the other states between which the treaty is being applied provisionally of its intention not to become a party to the treaty. To be continued.